Hello, Dr. Bengali.
Hello, hello. Hope I'm audible.
You are, but I think maybe it is just me, but the volume is extremely low. If you could maybe try speaking closer to your mic, it would be more helpful.
Okay. Yeah. Now I hope it's fine.
It's still quite low for me. Let me just ask my other team members. Um, Aisha, if you're here, are you able to hear better? Or Gunjan, can you hear Dr. Bengali better than me?
No, I think his mic is slightly inaudible, or let's say low on the volume, as you
Okay.
said.
Okay. Just a second. Just a
Yeah,
second. I think.
yeah. We have time. No worries.
Yeah.
Aishwarya, are we waiting for Tessa to join? Your mic is off, Aishwarya. I can't hear.
Yeah,
Hmm.
yeah, yeah. We're waiting for Tessa to join, and we're waiting for a few of my other speakers to join as well. And
Okay,
then
perfect.
we can, I believe we can wait another few minutes, and then I think we can begin.
All right.
Okay. Yeah. I hope now it's fine.
It's much better. Yes.
Yeah.
Slightly better.
Yeah. Thanks. Thanks.
We will wait another 2 minutes, and then we can begin. Oh, we do have Tessa. Tessa, hi. Can you hear us? Just checking in. Tessa, are you here? Can you hear us? I see you in the meeting. Wait another minute to see if we can unmute Tessa. Okay, we will begin. I'll request all our speakers to kindly turn on their cameras at this time. We will just begin with our introductions. Gunjan, would it be possible for you to turn on your camera, please?
Yeah, I'm here.
Just making sure
Hello,
we don't-
Aishwarya. Hi, Dr. Swapnil. Hi,
Hello.
Pranjal, Ranjan.
Hello.
I
Very
can
good.
see you. I'm fine. Can we check in with our locations? Probably just to quickly tell each other where we are located right now.
Yeah.
Currently,
Absolutely.
I'm in
Nashik.
Dehradun.
I am in Pune.
Yeah.
I am in Pune.
Yeah.
I'm in
Lovely.
Berkeley, California.
Swapnil, sir.
I'm in Nashik for a matter, so had to stay here. I was supposed to reach Pune tonight, but then I thought, like, firstly I'll complete this and then go, because in between the travel it's sometimes difficult to get the range. So
Great.
Perfect.
Good evening, everyone from India. Welcome to this webinar today. Thank you so much for taking the time this evening to join us. We're going to be talking about transformative contracts and their value for businesses. This webinar has been supported with Legal Design Arc, which Gunjan runs. I'll go into introductions in just a second. MyLawman, and also DreamLegal and SpeedLegal. Where I work. I'm the co-founder and head of legal at SpeedLegal. My name is Aishwarya Saxena. So welcome again to the webinar, and thanks again for joining. I'm speaking to you right now from very early morning. It's about 5 a.m. here in Berkeley. And this is a great way to start the day to talk about innovation and legal design and all those things. And thank you to all the wonderful students and young professionals from India who have joined us. Really appreciate all your enthusiasm. The way we'll structure the webinar today is, for the first hour or so, we'll be talking with Gunjan and Dr. Swapnil Bangali about legal design and transformative contracts. And then for another half hour, we will be speaking with Pranjal and Ranjan about topics relevant to young professionals and students in India, and the many career opportunities that Legaltech has opened up for students in particular. After each session, after the first session, we'll take about 5 to 7 minutes of Q&A. And after the next session, 30 minutes, again, we'll leave 5 to 7 minutes of Q&A. During the webinar, we request everyone keeps their mics turned off just to not cause disturbances. And during the Q&A session, you can raise your hand and we'll unmute you. You can go ahead and ask your questions. So just to kick things off, we have an amazing bunch of speakers today. Dr. Swapnil Bangali, he is an academic and a practicing attorney, an expert in legal design. We have Gunjan. She is an assistant professor at UPES in Dehradun, and she is also the co-founder of Legal Design Arc. They do really fantastic work, which I'll let her talk about in just a second. And then we have the co-founders of DreamLegal, Pranjal and Ranjan, very inspiring entrepreneurs. So you'll have a lot to learn from every single one of them, because each one of them offers a different set of expertise and a different set of experiences. So I'll let Professor Bangali kick things off. Please tell all of us a little bit more about your work.
okay, well, thank you so much, Aishwarya. Thank you so much, Gunjan, firstly, and thank you, SpeedLegal. Gunjan was an amazing, communicator in the initial part. Like, she gave me the idea, and I just simply, drove myself a little crazy when we had our first conversation, especially regarding the, the way in which we are trying to simplify the contract and all. So just to give a brief background about me, I'm basically a practicing attorney in India, and been appearing in multiple high courts as well as in the lower courts. And my area of specialization basically is IT law, information technology law. My PhD is into Information Technology Act only, and other matters which are like as we always say that technology is something which is touching our world by leaps and bounds. Like it's an amazing feeling that somebody from a different background suddenly discussing the way in which the contract is getting carried forward, especially with the impact of technology. That's possible. And even today's session, like somebody sitting in Nasik, somebody sitting in Pune, somebody there in Dehradun, somebody's in US. See the way we are connected. That also shows that there is a prevailing contractual adjustment existing, right? Without having a Google Mail link or probably the Google itself working for us. It's in a way a contractual arrangement that sees us together today, right? So that's something which I see potentially very, very important. And yes, I mean, if we are floating it on, like, then I would definitely would like to carry on from here. Like, shall we
Right.
start on from here? Yeah.
Right. So,
Yeah.
I'm catching the baton, I think, quickly. And yes, I was elated when Aishwarya sort of came up with this proposal to sort of discuss the kind of work that we're doing on contracts. And I looked at the kind of work Sir has been doing for quite a lot of time. And so one thing that we do realize in academia is, there's a essential need to connect the learning to the action. And which is where, like, I think both of us sort of connected on the first call as well, where I spoke to you about how we're working on contracts which are now, like actually engaging the people, and there's increased understanding. And that was coming from a learning that, we're teaching contracts. All of us are telling students what contracts are, what the act is talking about. But then it's not really addressing, like you said, we're all sitting at different places, and there's some synthesization, there's some dynamism to the way contracts are being, like sort of signed or agreed to. But there's an essential need for understanding these contracts too. So, Dr. Bangali, because you've been sort of working in the area for a very long time, and you've seen the practice, and you've seen an evolution of contracts, how they were before and what happened to them when there was such a technological transformation that happened. I'd really like you to sort of kickstart with what was contracts like, and what is it now looking like? Well, like, what was the foundational face of contracts at that time when you started off?
Yeah, thank you so much, Gunjan. See, basically, I would say it's seen a sea change now. See, technologically, it's more advanced. It's a different ball game altogether. Just simply to put it, in a very simple way, that whatever we were doing in the past, in small manner, like even a smallest set of a transaction where there could exist a barter or there could exist, a kind of an exchange taking place. We never thought that it could go beyond an oral and a written contract, because there were only two types which were tickling the mind of an individual when he used to enter into a contract, sort of. Right. But now, if you see what mesmerizes me more as a law student is that the kind of or the types of transactions that we are seeing, and more than that, how as a law student I would be in a position to put them in the jargon and say, see, this one jargon is only of those commercial contracts where these sort of things would happen. For me as a law student, I see it like, just take an example. For example, if I have to say that, as a lawyer, I want to, tell some junior or probably an intern, a law student, something like, just write down 5 or 6 different new types of contracts. See, his mind would be absolutely puzzled with the scenario that, see, we are not talking about just usual oral and written contract. There would be something impeccable going on in his mind. The first thing which might commercially strike his mind probably because he's, a commercial law student, maybe. He would say, "Boss, I think something like a vendor or distributor kind of an agreement." See, I don't see that word ever in terms of vendors agreement or suppliers agreement in law of contract anyhow, right?
True.
Rather, there are some interesting things in Indian Contract Act which sometimes mesmerize me even now. There's nothing written about the agency contracts with consideration. We all know anybody who is acting as an agent demands a commission, demands a brokerage. Nothing is written about it in the Indian Contract Act.
True.
How are we supposed to validate that consideration if nothing is written about it? It's a presumptive understanding, right? So there is too much at stake when somebody is drafting a agency sort of an agreement. So when I said something in relation to vendor or suppliers agreement, just imagine the supplier would see it from a very basic background that, see, I'm going to, supply you with some sort of a software or some sort of a technological know-how. What would be the extent of my liability then? I am just selling off and I'm just pulling my hands off. I'm not at all bothered what happens to it once you take it on, right? Now, how are we going to fix up the liabilities in those cases? See, we are a different world altogether. We are moving into a different world altogether. I like that word, when first time the topic was opened, transformative contracts. You see, basically, the legal system itself is in a transformative matrix. Just imagine, all of us, the social media, can there be a validity to the contracts which we pull it through social media? We are finding in India a very different thing when 2021, IT guidelines came in. The whole world got suddenly stuck at one thing that, now the government wants to go through every minute detail. They want to know the first originator from where
That's
do we
a
begin.
huge hue and cry.
It's a huge hue and cry. The whole world is like, you don't want us to do business in India or what? Why are you demanding it so much? Right? And the government simply, with the notorious executives, they'll just simply smile and say, "See, the government is not concerned with your privacy at all. We just want to know who is the first originator." Come on, when IT Act in India was passed in the year 2000, they said that originator and acceptor are the parties to the contract, are the parties to the communication. So whenever that communication is taking place, definitely we need to know who he or she is, who is entering into a communication device. So definitely now the jargon is open for such kind of agreements where there is not just only a two-party scenario coming into existence, because in the previous set of contracts, the man-made contracts, or probably machine-less contract, I would call it, where it was very easy, A versus B, A and B entering into contract, done, dusted. But now, if I am using one service provider, the other party using another service provider, definitely the whole game has changed. I can't now say that my electronic contract is a kind of one or two party contract altogether. It's always multilateral. And
multiple stakeholders now.
Multiple stakeholders. And your liabilities would definitely differ. So now when I'm entering into a contract which is highly technical, I have to understand the nature of transaction one, and I also need to look up to the modality, which I was initially not concerned of as a law student. As initially, A has sold a vegetable to B has agreed to the price to pay, and then that's it. He got it.
True.
What has happened is that more the technology we started using, the complexity has also increased. And complexity not only increased at the level of the parties who are entering into contract, but also the complexity has increased in relation to the service modules of contracts, which are interdependent on the primary set of contract between the two parties. That cannot be overlooked. So for me, as I said, the first opening point would be the jargon, knowing the jargon, where exactly I'm putting it. Probably, I would say, as a modern law student, I would say that there would be too many pigeonholes, and then I have to, pigeonhole every single subject matter. Some of them would be vendors and suppliers agreement. Probably, God knows, software you might be aware of software. There are some companies which are only selling softwares. They would come up with, only the customer-centric relation and customer as a base of the contract. You would go for something like SaaS agreement. Who knows? They would look at it from a completely different perspective. They are not at all.
I like notoriously call it monologue contracts.
Monologue contract. Absolutely.
That's a good way of putting it.
Yeah.
Good way. Like,
I
it
mean,
doesn't facilitate the
yeah,
communication.
just imagine, like, just by saying okay or without even saying okay, my basic premise, which is taught to me by a contract law professor, that there is something known as free consent, is not even seen. That
Right,
it's just that's
right.
it, that's gone, right? And
Agree.
we have to be more careful nowadays when we are actually clicking the button and say that yes, I do accept, or I,
True.
have seen the agreement. So yeah, definitely, Gunjan, you are absolutely right. Like, it gives me a goosebump when I say that, suddenly on a laptop or a computer, something is automatically happening, or, like people talk about, like, validity of shrink wrap contracts or click wrap contracts. It gives a goosebump because probably the expectations from the concerned person who is entering into contract is far more different than what we are actually anticipating.
True.
I would say my device could be something like a pet.
Mm.
Like if my pet bites the neighbor, I cannot say to my neighbor, sorry, I did not do you, my dog did, so we're sorry. See, the same way, if something happens through my device, it's my pet. I can't say it didn't happen on my device. It did happen on my device. So I'm always responsible, right? So obviously the complexity level is completely different, and there is a very huge potential for simplifying this thing. And I think
Mm.
the first step could be the, as I said, pigeonholing, jargoning the whole thing, create the jargons differently for different types of contracts. Something
Mm.
that was coming to my mind a few days ago, that, in India, if somebody wants to, just make out one type of contract, which is, very, very much required, like somebody should really look into this: service agreements.
True.
Just imagine, people very fondly talk about MSAs, master service servant or master service agreements. I mean, there are so many engineers, there are so many technical background people who suddenly call up and say, see, we are having a very different enough scenario here. My company says that I've signed a bond, now you cannot leave the job in between. We have to give a 3 months notice. We have to pay 3 months of salary, return the
Mm.
salary.
Mm.
And on
Mm.
the other side, they also say that there is something which is known as non-disclosure kind of an agreement, where,
True.
one prototype we have designed in one particular company when we were doing the job, and now they are not allowing me to use that knowledge somewhere else. And
Mm.
is it not my right to livelihood that is at stake? Because, the new company is offering me a higher position, a high salary, and suddenly this man says that no, you can't join that company. How is this possible?
Right.
Just imagine
So,
that master service agreement itself might be of, like, I don't know, probably some of them are not aware that there is no clause on indemnity or indemnity caps being mentioned. Still people blindly signing it because they think this is required to get a job. And now, and these issues unfortunately are not even coming from the horse's mouth. I would always say that because, we have seen the situations even in the Supreme Court or High Court. Decisions are there, ample, like on a principle or a provision, you find hundreds of decisions of the Supreme Court or High Court. But unfortunately, if something is coming up as new or as, on the rocky surface like MSAs, I, as a lawyer, have to first convince myself that yes, this falls into one particular section. Then I have to convince the judge to say that, see, even though it is not directly written as MSA, as a master service agreement, still it exists. Boss, come on. I mean, my client is right on this side, right? So this is
true.
something which is very, as a law student, I think that somebody has to simplify this area.
True.
I mean, a very obvious thing that comes to my mind is the potentiality of risks that we are talking about. I mean, if somebody is entering into a contract, it is always the proportion of risk that is in existence.
Mm.
We cannot
Mm.
surpass that. If I keep on hovering around at one same subject matter again and again and say, see, this is the way we did it in the last time, so it's going to fetch the same outcome, and so the liabilities are managed somehow. I would say, oh, come on. I mean, each individual comes with a different expectation from a contract. Each single transaction has a different flavor sometimes. How are we able to simplify it to that level where we understand what exactly would be the outcome?
And I wanna build on that very quickly. I think you're bringing up very important points. Dr. Bangali, you're talking about this kind of being inefficient for individuals, like individual vendors, like service providers. They don't understand their rights within the document. The businesses don't really understand what are the different roadblocks or what are the different areas that they need to navigate and be prepared for. And just the regular individuals, the clients, they are far from understanding what their rights and obligations are under these contracts. So we are in a situation where no one really understands truly the extent of their rights and obligations. And when I think of these issues, I'm thinking about what are contracts. At the end of the day, they are documents that establish relationships. And to think in very simplistic terms, the key to building any sort of whether that's a client relationship, whether that's your relationship with your friends, it's all communication. And these documents are really not helping out with that. So if you had to sort of come up with some sort of a methodology, and Gunjan, I'd also like for you to jump in on this with your legal design experience. If you had to maybe put together a methodology, how do you simplify that? Is it getting rid of jargon? Is it changing the way that we're using jargon, I guess? Is it changing the way we represent information? What would that mean for you? And we'll start off with Professor Bangali, and then we can go to Gunjan.
So, so you beautifully put how, there's a void. So establishing this void is extremely difficult these days, given that we have, sort of accepted that, okay, there's a prompt coming on a website. As soon as I enter, it says accept cookies. I'll immediately go and do that. I do not know what I'm accepting. So similarly, I want to make an account on, let's say, Twitter. Then there are a couple of things that I have to agree to, where the instantaneous reaction is that I want this service and I jump to the service because I need the service. But what am I getting into? Establishing that disconnect is very difficult. And you beautifully put it that, when I teach contracts to first year students, and when I was being taught, I remember those days, and similarly, so there used to be two parties, party A, party B, and the transaction is essentially between them. Now, given that we've been able to establish the fact that there's a disconnect, I came up with something, really beautiful when I was in London, when I first started, experimenting on contracts. That's how I put it. And we were given this a service agreement between law service provider, and in that agreement, sort of, they had certain certain terms and conditions for the person who they were engaging. It was essentially an employee, not even an employee. It was like a freelancer who was being tied up in certain terms. Now, how we at ARC look at these contracts is we segregate the usability. So legal design essentially is about empathizing with the user. So the stakeholders that are involved, once we start empathizing with those stakeholders, we realize that there's a processing part of a contract, which is basically making the contract, agreeable, or let's say, and there's one part which is binding, which, let's say, substantial part of the agreement, which is telling you exactly what you are liable for. So the jargon is in the part where there's lack of understanding. Let's say I say that so-and-so person is bound by so-and-so term. The employee shall not leave the premises for 8 hours straight. Something like that, if that's a term, that is a substantial term. That is making, creating a liability and a right. A right of the employer and probably a liability on the employee. That part of the agreement, if I put 20 other words additional to the fact that 8 hours, you should, the essential objective behind it is that 8 hours you have to be in office. But if I write that the employer acknowledges that the employee would, so that is adding jargon. that is confusing the person who is actually agreeing to that term. So
Correct.
we realize that this part of the agreement needs to be dealt with.
Correct.
Apart from this, there's another need that is there, that is created. And this empathizing process also took us to that, wherein we said, how many pager contract is it? It's like 100 pages. We're like, oh my God. So how would you expect an employee to take a call on an employment agreement immediately,
Yeah.
which is 100 page? The processing time is so low.
Yeah. See, as a lawyer, as a law student, I would always say one thing that, see, whenever I look at a contract and whosoever is my client, the first thing I say is like, what are you getting out of this contract? You see,
True.
there is
What is
a
the substance?
bargain. Yeah, there is a bargain all the time in the contract.
True.
So I always say, are you reducing the risk when you are entering into contract? Is
Right,
it contract, the contract is beneficial and improvising you? I mean, Aishwarya has really nicely put it up that, it's relation building process in a way. But see, the problem with relations is either they end up in end of relation in terms of ending of relation, or in terms of the end of time, right? They superannuate. Unfortunately, we don't mind it, having a relation getting superannuated by time. But the problem is with relation getting affected by it, right? So
how does it
that's where it
terminate?
is. Yes.
True.
So I always say this, that there is, as a law student or as a lawyer, I would always look at that point, that how you see as an individual that how much my risk is covered. I always tell to my insurance law students that, you are not just making an insurance contract. Please think of something of every bit of contract, like, every side of transaction, like an insurance contract. Like a very, I am originally from Pune, and in Maharashtra, in Pune, they say that the people over here are very, very bargaining. They will never live, one small thing also here and there. Nobody should miss out with that. One has to be that vigilant that, there, I always see this, that, there is always a possibility of reduction of risk through contract. So if as a good drafter, or as a good communicator, or as a good transactor, I would prefer my risks are lesser and lesser, and at the same point of time, I am having control over the terms and conditions. If that is what is happening, my control, my nexus with that bond, with that contract is more solid. I also would like to bring in a very important facet over here. Gunjan just simply mentioned that, I like that expression, 100-page contracts. You see, suddenly turning ugly. The, lawyer wants to show. I tell you, there are many lawyers probably, would look at each other and say, well, some of us, we all know that, within the practitioner's zone, I can say that, see, actually it made only 7 pages of sense, but what do I do? It's the client who has paid me so much, so I need to have those 93 pages somehow making some sense, expanding those 7 pages to 100 pages, right? So it's all
this is something that just exactly what happened to us. It was a 100-page contract which was consolidated into a one web page thing. Like just one web page. 100-page contract was consolidated into a one-page web page altogether, where you can see exactly what you're getting into. And those techniques, there are certain techniques that we did use to, simplify this jargon. And like Aishwarya asked, that exactly what are you doing to these transformative contracts? And they came out with certain really nice ideas, like, bolding. This is something we don't do to contracts. What do we bold in a contract? Headings. There are essential things that need to be bolden. So emboldening was the basic at which we started. And then it went on to, why not add videos? Why not add animations? Why not sort of add, let's say, frequently asked questions to address certain queries that does not essentially need to be a jargon in the agreement. It can be an FAQ. Why not add that? Why not add, let's say, some text bindings? Like you put certain words together to make sure that they make sense and they immediately give you the sense of what you're getting into. Or probably just putting subheadings in the right places. Like, these are
Right.
little things that you do, and or maybe make an infograph. Another
Mm.
interesting imaginative thing that came up was, why not put a storyline? Let's say it's a agreement between you have travel agencies, and they have
Mm.
agreements with clubs and all. So in the way of, let's say, a journey, probably develop a contract around that, engages the person instantly. So it's
Mm.
catering to the sense of not reading only, or not only writing, or not only understanding in like those, engaging those two senses like visual and auditory, also
Mm.
engages the other senses of, sort of maybe processing, of
Mm.
grasping, of like creating an animation in front of you, that okay, if you this is something that has been done recently. I've seen one of big IT companies do that, and they converted, and that was, I think, if I'm not wrong, it was Twitter. A couple of years back, they'd introduced a like slight animation video where they were, this is what you're doing, and that was
Mm.
basically telling you your liability in a very
Mm.
short and sweet animation video. You can actually convey what is the risk and liability. That's just exactly what we were trying to do with it.
Yeah.
And then came the processing part. So why develop it as a web page? The question was, okay, you have to do this. You can do it on a paper and pen. But where's the fun in that? Was the question. That okay, you go back to the pen and paper, and that makes it boring. And also, you can't. Paper and pen cannot cater to animation. Paper
Right.
and pen cannot cater to the IT creativity around. So we
Mm.
ended up developing a web page altogether, wherein
Mm.
um, processing was quick. You could, the click wrap could be used,
Mm.
and apart from that, you had we like brainstorming then also leads you to smart contracts, and binding in a minute, and probably closing the transaction at that very location and space, so that the processing time decreases. I mean, that's
Mm.
where a lot of loss also happens in the industry. I hope you'll agree to that. um,
Yes.
uh, there's a lot of money and time that is lost in negotiation of that contract, and that rampant
Mm.
negotiation also happens to put a like delayed time to, because
Mm.
it keeps on going back to the stakeholders.
Yeah.
So you had the
Mm.
idea of smart contracts.
Right. Right.
Yeah.
Yeah. See, there is something really interesting that is currently happening. We are representing a company in the High Court, and
Mm,
something Gunjan, you have just mentioned. We have the similar kind of situation, especially having a chain of distributors. Just imagine, I mean, there is a sugar factory which is having more than one distributors. One of the distributors buys the product, second person has already, third party has already paid half or probably less than the half amount. So the distributor transfers the entire set of goods. It's almost like, I think, some thousand metric tons of sugar, and
mm,
without even taking the physical custody, the this seller of the sugar exports that sugar out of India. Right, this is the
mm,
whole
mm,
chain of transactions that have taken place till now. Now suddenly what is realized by the sugar factory is that they have not received the full payment. So
mm,
in the agreement, what they had stated is that sugar factory is free to create a series of agreements. So it's basically written in the clause that they could also make an agreement subsequent to the sale, because they have
mm,
an yearly different kinds of contracts, part and parcels of
mm,
contracts, series of contracts, basically to say.
mm,
Suddenly they just overturn a page, second league of contract comes into existence, and they send it to the first distributor, and they say that you just have to sign and send it back. All other conditions are already prescribed in the first set of contract. Now the second contract states that you cannot go full 100% of exporting
mm.
unless and until you pay 100% payment. This was not
Oh.
written in the first contract. Hmm? Now, this the distributor, without thinking much, simply signs the contract, and says, yeah, it's mine, because I don't know the current location of the current goods, like, those which are there. He just simply sends it back. And third thing, what happens is the notice is being sent by the concerned sugar factory to the concerned company, distributor company, that if you have signed it, that means we presume that there is 100% sugar existing in India. Now this man has a goosebump. Now he simply says, see, I didn't mean it this way. What we have written in the first contract, I stick to that. This is something which I thought was just a secondary kind of an agreement. So if the primary is okay, then only we look at secondary. But now you are saying that you are presuming. No, we cannot presume things in the business, right? I have given it to the third party. Now they send the notice to the third party. Third party simply comes in front of the court and says, hello, we have the lawyer makes a very good fun of the commercial judge in the court, in the commercial court, and he simply says that I just want to ask one simple question to the other lawyer, to the plaintiff's lawyer. Do we have any contract with you? The man says, no, we don't have. So that's it. I rest my case. We have no contract with sugar factory. How can they charge us? Like, how can they make us defendant? I'm just moving an application from, removing my name as a defendant. Just imagine. Shocker. It was 1,000 metric tons of sugar. It must have been somewhere around, I think, $700,000 or $800,000 kind of figure, which we are talking about, like a huge setup of a contract. And suddenly the man comes up with a very gloomy face and says, oh, we should have drafted it rightly, right? Like, is it falling into this or that side? I said, wait, see, as a distributor, if I have a contract with the sugar factory, that is a primary contract. All other contracts are subsequent but subsidiary contracts. If the primary contract exists, then only the subsequent contract exists. I cannot presume the existence of goods here. Yeah, it was a very beautiful story that, subsequently that had developed, that, there was an insurance taken. What about the insurance company? So one insurance company says, oh, we had a very clear-cut policy. If the goods exists, then only we, continue with the insurance. Consignee says, consignee suddenly comes before the court. I don't know from where he was like, that the characters in the Bollywood or a Hollywood movie suddenly appearing and making everybody laugh. The consignee comes up with an affidavit before the court and says that, see, I have not made the party, but I am filing a caveat over here that if something goes wrong with the sugar, I am not responsible for it. See, I have been, receiving the payment from this party, and so I have consigned the sugar to the other country. Then suddenly somebody crops in and says that we know that there is a letter of guarantee signed by the sugar factory which says that this is not the export quality sugar. Imagine, there were around 17 parties appearing before the High Court, stating that we are somehow interested, and everybody is confused with his or her part of contract. Now, this is where it is. When we are having multiplicity of parties, we cannot simply say that if I am looking at one way contract or one type of contract, I would be able to get what I exactly want the contract to result into. So for that, I believe there has to be something like, control of the contractual data. I call it control of terms. One has to understand it, that, see, if I'm making the terms of a contract, whom am I making it binding to? People have a very fantastic way of explaining it. Some of the lawyers have actually written it like this: any party whosoever, these are the usual words, any party, whosoever. I mean, wait, whosoever means that suddenly that right in personam has been demanded to write against the whole world. Come on, the contract is a personal law. It is binding the two parties. I mean, we live in the country where we all believe in that the whole world is one family. But see, I can't divide everything in succession to everybody whom I know, no? Right? So there is a difference in that. It's a very proud feeling to say that as an Indian, we look up to another Indian as a fellow brother or fellow sister. That doesn't mean that I would contractually set it out to say that, see, we have simply those who are not essential parties to the contract, I'm making him party to the contract. Now, one has to visualize these things, that upon whom the effect of contract would be. If I am in a position to draft a contract in such a way that I avoid the generalization and I start controlling the terms, start controlling the data versions of it, like how am I putting the data into that contract, then only it makes sense. And
Right.
lastly, I think there is one more part which I would like to really just take up one single liner over here. That most of the time, what happens is, as a lawyer, I've seen that many lawyers make just one version of the contract, which still for me is a very big surprise. There has to be multiple layers of understanding.
Templating.
Template.
Yeah.
Exactly. I mean, they have like sense of understanding. Parties might be N, but the contract's draft is one. That's it. You know,
True,
N
true,
is
true.
N is equal to one. There's something which the mathematician has put into the lawyer's brain and state. You make some space. There's only one. I understand the contract by in a binary language, like computer can't understand other than 0 and 1. Lawyer also can't understand anything other than 0 and 1. So let's make it one. It's a unified
So,
contract process, which shouldn't be there. I
right.
always feel it that a lawyer should have different versions of contract. Today he feels that okay, there are only 7 essential clauses which should be part and parcel of entire set of risk, entire set of effectualities that should be taken into consideration. He should not stop at that. Give yourself some time. It's not today that you are ending up with a contract. Mull over it, think over it.
Right.
This is where the research comes in. You have to research it, that what are the possibilities, how it's going to happen. Recently we had a very interesting case where there was a JCB kind of a pulley kind of a machine that has been carried on. It's a vehicle basically. It's been carried on a huge truck, huge trailer, and suddenly it slips over and then it falls onto a small car. It's simply converted into a wreckage. That's it, simply a scrap. Now, the first thing what the carrier guy says is that in my contract it is clearly written that if I am not involved into an accident, my liability does not exist. The vehicle owner
Right.
says, but I have sustained a loss. Who's going to bear it? They just point out the finger at that, the manufacturer of the JCB, or that, the
Terms
pulley
and
kind of.
conditions.
Then he says, sorry, I mean, my vehicle is literally not a motor vehicle within the definition of Motor Vehicles Act in India, because it is not registered yet. I mean, if you have a registration number, then only my vehicle is a vehicle. And another lawyer comes up and says, oh, wait a minute, I mean, the vehicle was not even running. So if it is not running, then it is not an accident. Imagine, I mean, the way,
Complete, like,
yeah,
mess. It's
yeah,
like
it
we're
is.
playing, like, that game called like Grapeline. Like, you tell
Yeah,
someone something, and then like by the time it gets to the other person, it means something completely different.
yeah,
And I really think that a lot of times, especially with like the sugar deal, the sugar consignment case that you're mentioning, clearly
yeah.
wasn't that sweet of a deal. Like,
Yes.
no one, no one really understands what's really going on. Like, if they are even affected within that particular litigation, and it's so like painfully common. And I want to sort of follow up on that and just ask, because we've touched upon the problem, right? Clearly there is a problem. Gunjan was talking about all these fascinating ways that we could like visualize, we could use animation, and really like thinking about it from with like an empathy for the readers, like the clients, like every stakeholder involved. And Professor Bangali is talking about, like controlling the terms, like really ensuring that you take a tailored approach to every type of deal, and you really make sure that the focus is on making sure that everyone involved in this transaction understands what they're doing and what they're not supposed to do. But I think like apart from just like having like solutions, we need to have like a sustainable way of making sure that we really change the legal industry and like the way we approach contracts. And I think this is such a great venue to be discussing this, because we have so many students. And as an academic myself, I think that's kind of where my heart is. I think like students, like academics, are really like key to like creating this sort of like a lasting change. So Dr. Bangali and Gunjan, I want to ask your perspective on what do you think about including legal design and legal tech in law school curriculum, where students are taught about these subjects sort of from the get-go, so they don't become the type of lawyers that are drafting these sort of contracts, and they can like shift the norm. And before I hand it over to you guys, I also want to announce to the audience, at this time we are going to be taking your questions. So as Professor Bangali and Gunjan answer this question I've just asked, please feel free to raise your hands, and then we'll go through your questions one by one.
So, coming to the point where, as a curriculum, how do you inculcate that value in a student. I think Professor Bengali would agree that now we're like really facilitators in a classroom. We're not really teaching them. We're not even professing. I deny to agree to the word, you're professing. You're not even professing. Facilitating in that classroom, probably, because that knowledge is everywhere. People know what is legal design, but how to apply it is what needs to be, inculcated, which is why I'm using the word inculcated. I'm not saying teaching. So there is a really grounded need, something really full of gravity, which can bind together the knowledge that the students are getting in the colleges on, law and how they're applying it. I think apart from legal design, which essentially is the theory, I say that, it's a theory behind ideation in law. So that theory can be facilitated to the students, inculcated as a value in the students. But there's another aspect of what is happening in the legal industry is law tech.
Yeah.
And law tech has captured the industry commercially. It's like a gold mine right now, and fairly so. I mean, there's nothing bad about it because access to justice is what it is catering to.
Yeah.
So, this legal tech is essentially about developing that skill set to ease
Right.
things out, to ease processes out, and this skill set development requires a, rampant usage. Let's say it's like getting conditioned to using these tools day in and day out. Like, for example, consideration is a concept that needs to be, taught to the student because he needs to remember. He needs to use that value every day as an equation when he is dealing with contracts. But that's something that we are already doing theoretically. But are we, sort of catering to the need of students where the moment he goes into the industry and there's a law tech tool that he has to use, are they being able to use that immediately? I don't think so. And that's where the problem arises, wherein, let's say, I sort of myself, I'll give my example. When I started off and I was an intern and I went to this amazing top tier law firm in India, and I had no idea about this templating. So there used to be playbooks that would be used, and that's something that everyone's doing in the industry. We have playbooks around, so and so entity has such and such contracts, and they want these terminologies, and there's a playbook. Now, to access that playbook, you have a certain, software that is processing those terms, and you will get to know exactly which ones to change. This was not taught to me. I had to literally struggle to work on that software. But why are we doing this to students when this is a need in the industry? So I think that skill development is also very important. That law technology skill development in law students is essential. And inculcating the value of legal design so that they can empathize and understand what's the problem and be more creative and innovative with their solutions. Probably that is going to make future lawyers amazing. That's how I'm seeing this whole, industry evolving with legal design and law tech. So, Aishwarya, that is, I think, my perspective. Dr. Bengali, would like to add with your experience?
Well, Gunjan, when you were speaking, suddenly one more subject matter came to my mind. See, the whole world in terms of technology is looking at something which is known as metaverse. Yeah.
True.
I mean, just imagine somebody as a lawyer would be eager to do it. Like, what are the damages? What are the remedies? What are the rights of two individuals ending up their contract for a virtual world in future? Well, initially it would be more of like the same set of wordings for many, like, how we are going to take it forward. But at the same point of time, just imagine if it is affecting something which is in the metaverse, Are we allowed to have an action in the real world?
True, 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 true.
Including that of a suit in the court, including that of the remedies that are there in the court, or
True.
probably something, as we always say, that there are certain set of things which would be the way in which we look at the agreements from one set of perspective. So probably, just through the chat box, there was one question I was looking at, and it said that, do we have a, future in the times to come? Like, if you see something like legal tech coming very close to us in future. Well, I always believed that, it's something which is affecting us all the time. If you want to look at it, then you say that, yes, it is in existence. If you don't want to look at it, probably you are already been part of it. You just deny to accept it. In cyber criminal world, we always say that there are only two kinds of people. First category is those who are victims of cybercrime, and the second category is those who don't know yet that they are victims of cybercrime.
They are victims.
Yeah, I mean, in the same fashion, I would say either we are, very close to accept the legal tech, and or we are not aware yet, but we have already been through it. This way or that way, we are affected by it. So to make the thing very simple, just accept it in a very simple manner, that if you don't accept it today, you will
deficient tomorrow.
You will be deficient tomorrow, or probably even I would go something beyond that deficiency, Gunjan. I would say, even if you don't want it, you will become part of it. So, like, avoid the line would be avoid the unmanageable or manage the unavoidable. That's
unavoidable.
Yeah.
Perfect. So I think I just share one incident that recently happened. So I have a client over in India. They're like working in the meta space, and they came up to me and Professor Bengali, I was tied up. The moment you said the last part of that statement, I was like, yes. So as a lawyer, because my understanding of meta is really limited, I come from a humanities background. And it's for me to go back to understanding how this is working was a whole lot of reading. That is another thing, that you're literate and you can read and understand. Like all over these years, you've gotten conditioned to learning. But the question was that, can you how does the dynamics of intellectual property work in meta?
Yeah.
And my client was like, I want to protect it. And he was like, my lawyer, tell me how will you protect it? I was like, okay, perfect. Give me that space and time to understand whether an act in the non-virtual space can be applied in a virtual space. And can that bind somebody, some entity in the virtual space? So these are questions that are unanswered and will remain unanswered if we cannot empathize with that situation. And we cannot pull down the stakeholders to a liability in the non-virtual space. So I think that was a dynamics that I was through. And I think students should not be through it when they are in the industry. So we need to really, ramp up and, sort of update our curriculums and tell them, no. Okay. So if there is the void, you have to think like this. So legal design will inculcate you think of, this is the void, these are the stakeholders, this is how I have to cater to it. And what are the tools I can use? How can I understand? Probably have a basic foundational understanding of what is meta, what is codes, how are these people, connected to the physical world? Who are these people? How can you identify them? So something similar to what happened to the IT Act. The fact that they've tried to ground that identity through that IT regulation that came. And something similar to that in the meta space you'd have to do. So I think that, and We can move to the questions now, Aishwarya. I think this discussion is really interesting and it'll go on as much as we want.
No. I'm here for it. Yeah, so we're all here. But no, like really fascinating points, and I think it's crucial to have that sort of like forward-thinking approach because the industry is evolving, client needs are evolving, and I think academia needs to keep up with those times and prepare like future lawyers to be ready to handle and answer these sorts of questions. And speaking of future lawyers, we do have a lot of students with us today. Professor Bangali already answered the first question we had about whether we see legal tech become a subject in law schools. I also want to kind of weigh in on that very quickly. In the US, like legal tech is very much part of legal education at the moment. At Berkeley, there is a class where you actually get to build like a product, like a legal product, as part of like your semester, and you just work with this expert attorney, and together with them, like you learn a little bit of coding, and you actually get to build a product. It's a class here. Harvard has a course on that. Stanford has this amazing group called Codex, and they give students like grants and resources to research on legal tech and the integration of law and technology. So this is something that's very much happening, and I think in India as well, there are like legal tech companies that are coming up. And in just a second, we'll get to Ranjan and Pranjal, who will actually give us a good update about the biggest legal tech trends in India and what that means for students. We have one more question from Jayesh about asking Dr. Swapnil to very quickly talk about the rights of employees within an MSA.
Yeah, rights of employees. Well, it's a very huge subject matter per se, but yeah, definitely. Practically, one has to understand one thing that as far as the constitutional domain is concerned, right to work is a fundamental right in a way. So definitely, we cannot restrict a person from entering into contract. That's the basic understanding. Restraining a person from trading is not the idea under the Indian Contract Act, at least. Definitely, one might see it as a biggest protection zone for an employee. So that way, I won't be very much specific to that subject matter. But yes, definitely, when you say right of employees, I must say one thing that in India, people are very much fascinated by the idea of having a collective bargain. Like we say, like lawyers, we have a very good group of the as we say, bar and bench. The bar is so strong that depicts that the way you have a bargaining power with the bench. Similarly, if you see, there are certain set of bodies coming up, they have a very good sophistication in terms of rights of employees. So what should not be there in the term and MAS or MSA, the way the multi-layer contracts are created for master service agreements, there is a huge hue and cry in certain industries where employees say, sorry, for this I won't be liable. Yeah. So reversely, if I see it, it's like this, that at any point of time in certain industries, the existence of certain terms and conditions can be completely wiped out by the rights of the employee. But unfortunately, only in organized sector, there are only few, probably notable on the fingertips. Those small numbers of industries are having this kind of an arrangement. Just imagine, I had one fellow who had come to me very recently. He was working as a vice president of a very big company, had the data of that company for 28 long years on his, all those transactions on his laptop. He returned his laptop, and after 8 months, he gets a notice from the said company that 8 months back you were our employee, and it seems that there is something fishy about your laptop that you had returned it to us. So now we are suing you. And the man comes up and says that, see, boss, 8 months of time, I can't be made responsible for what happened in between 8 months. They say, no, but we have found a forensic understanding 8 months back. So that time you were in the job. Now, the biggest hurdle over here is, we said that neither the company nor the employee is in that position to know what exactly happened to the device within these 8 months. It might create a very fascinating kind of a discussion in the court to say, What happened during these 8 months, we don't know. So we are not liable. It's fine. But see it from the prospective or supportive liability or supportive rights of the employee. I would always go ahead and say that every single employee, whatsoever he is signing, whatsoever he is looking it into as a term and contract with himself and with the company, he should be very clear what he's signing up to. And he should say that, see, this one clause, I hate it, I don't like it, I have every single reason to refute it. This is how one should look at. And definitely something which is absolutely an impossible set of thing, or something which is absolutely beyond the scope of the duty of the employee, against that, the courts would not be reluctant. The court would be rather supportive towards the employee. So see it from this angle also, that it might be privacy, it might be something like, information disclosure or non-disclosure. Those kind of areas would be the ones which one should be looking at it from the perspective of an employee. It might be that whole liability rests onto the employee, but you have to understand the process and dynamics of the data in which it flows in one particular organization. So I can't crib about that fact again and again against the employee. We have already made it clear. It's an NDA. It's a non-disclosure agreement. You are always liable. Oh, wait, come on. There is a flow of information. The concerned employee is not the single person who knows this, right? There can be hundreds of other employees. There can be thousands of suppliers. There can be thousands of, stakeholders involved into it. That point of time, you cannot say that, see, this man knows it just because he has signed an NDA. This is the, I think, factor which comes to my mind when I look at employees' rights. And I think the law in India, somewhere it's now into its baby steps, especially when it comes to the technological jargon in respect of the disclosure of informations for the employee specific contracts. I'm just hopeful, probably within next 1 or 2 years, probably again in the similar set of discussion, you would call me, and at that point of time, like what I discussed about the sugar, or like probably what I discussed about the other set of contracts, we would be discussing something like this one, like, what would be the liability of, or the nature of liability for an employee. I think there is, there is no specification about it yet in the line of how we deal with. But fortunately, what I see is that the law has been more protective in both senses. If it is the sensitive information, or the information which generally carries a value of, like an IP, intellectual property, then people are more concerned, the judges are more concerned. But other than that, the protection towards the employee has been continuous, has been more solid. So I think it depends on case-to-case basis. So being a very diplomatic individual, I would like give the answer like this, that it depends on case-to-case basis. Rights of employees, probably.
Yeah.
It all depends on how much the employer needs me as an employee, probably.
Yeah, no, I think that's very, very well put. And it's like MSAs in general are such a complicated and almost like a precarious document to handle, because every vendor would have a different kind, and like based on the obligations or rights that are set for each party, like they're very difficult to standardize and like also interpret. So thank you for sort of laying them down very, very clearly for us. I think we had a second question about there being a lack of law with regards to transformative contracts, but I think Dr. Bangali, like in his answer, already touched upon that. And we also have Tessa who has joined us. So glad to have you here, Tessa.
Yeah, I'm sorry I couldn't make it earlier, but I'm really excited to be here and to catch up with you and with everybody in this webinar. So thank you so much for the invitation.
Of course. And Tessa, for everyone, Tessa is the CEO of Legal Creatives, and she also teaches legal design. She does a lot of interesting courses. She also has experience with a little bit of the metaverse, because that's a topic that came up. Tessa, you're just speaking about that. So it's great to have you here. And I also want to very quickly, get your insights on what you think is the true value of legal design and unlocking contracts for businesses and for individuals. So if you could quickly weigh on that, that would be
For sure, I would love it. I could share so many things, because legal design is such a powerful methodology in the sense that it gives us a structure, a framework, as well as tools and techniques that we can use to make sure that whenever we communicate legal information or contractual information, we do that in a way that is more user-centric. What does that mean? That means centered on the needs of the users. And so our customers are not lawyers for most of them. And given that they are laymen or laywomen, they just have a really hard time to understand the technical language. And what that technical language does is that it creates what we call cognitive loads. So our users have to process the information, and that requires a lot of energy for them to understand. And depending on their level of education, depending on their background, it may take even more time, and they're at risk of just dropping out and not engage with the document, not engage with the information, not use the information, and not feeling confident enough to use the information. So what legal design does is it gives us a structured methodology to be able to organize the information in the document, whether it's a contract or a policy or terms of use, and organize this information in a way that is going to get the attention of the contract users, also help them find what they need, quickly be able to use what they need because they understand it. And that creates a better relationship between the lawyer and the customer, but that also creates a better business relationship between the customer and his own customers, partners, and stakeholders. And so that creates quite a revolution, because we have not seen in law many different ways of doing contract. It's the usual block of text with the jargon and the legalese. And so now we're starting to see many jurisdictions around the world, those contracts being redesigned, and clients really loving it, because they finally understand what this all means. I can use what I read, and it just creates an effect, like a snowball effect, when after the contract is being seen and signed by others, they also love it. So it creates this kind of mini revolution in the contract world. We still have a lot of work to do in terms of the research, in terms of making sure that the information is really more effective. So we need to make sure that the legal design is done well, not just adding a little bit of colors and icons. We really need to follow the methodology, understand the users, what they need, how can we deliver the information better, and also go beyond just the contracts and the documents, but start thinking about infusing this methodology in the way we deliver the service, legal services, in the way we work together in law firms, legal departments, and the justice system at large. So I think in the United States, with Margaret Hagan at Stanford Law School, there's lots of great work done in that aspect of redesigning the justice system with legal design. In Europe and South America, we see a lot of contract design. I'm not exactly sure in Asia, but we've had lawyers which we have trained who are in Asia and also in Oceania. So I think there's starting to be interest in that, and that is really wonderful.
Absolutely, yeah. And I think you kind of painted a very clear picture of the different ways legal design can be impactful, and also how it's being adopted in different parts of the world. And I think with your comments, I think they're a perfect segue into the next segment of the webinar, which is going to be led by DreamLegal. I want to introduce Pranjal and Ranjan again. They're amazing entrepreneurs from India, and I would like to now invite them to tell us a bit about the biggest trends, global trends in legal tech and legal design that we're seeing, and what that means for students. And then once you're done with your presentation, I would loop back to what the things that Tessa was saying, and open for more discussion on this. And I also want to thank Dr. Bangali and Gunjan for amazing first part of the webinar. I think everyone really appreciated all of your insights. So with that, I'll hand it off to DreamLegal to do their presentation, and then we'll come back to discussing more with Tessa and DreamLegal. In the
Thank you,
meantime,
Aishwarya.
Thank you, Aishwarya ma'am, for the opportunity. And thank you, Gunjan ma'am and Swapnil sir, for the wonderful insights. I actually correlated my initial interactions with contract, that how it used to be so complex with so many clauses. And when I imagine, had it been contracts in the form of infographics and videos, wow, it had been so imagined, like it would have been so easy to refer to them. So like that was very fascinating. So I would start with that. Pranjal Poddar and I started DreamLegal as a simple blog, and I believe contract has been the nearest sector which has like kept legal tech alive, and that was the sting that like incited our interest for legal tech. But I believe legal tech as a career for law students has opened like many doors. I remember myself joining the law school. For me, legal tech careers options were like just judiciary, corporate litigation. But now legal tech has opened the doors for non-traditional careers. Let's say it's like marketing, let's say it's like managing of softwares, and it's like streamlining operations, how legal firms are functioning. It's very revolutionary how legal tech has impacted the career opportunities. So I would just take a minute to share the presentation which I and Pranjal has prepared.
go for it.
I confirm if it is visible completely to all.
Yeah, we can see it.
So starting with, I believe that legal tech as a career hasn't been discussed enough, because it has been believed that legal tech does not have that enough space still, especially in India. But actually, if we could just go with the stats, that how legal tech is booming in India and in the world, of course, it is like phenomenal. Like corporate law departments look like more to like 150% of spending has been increased to just adopt legal technology. And if you see about how startups are emerging, like seriously, 13 billion has been raised and 1800 companies has come up so far. And actually, legal tech has more impact upon how legal services and professionals are functioning. It can be delivered like with more flexibility. The cost has been reduced to so much. If you just see the first instance, legal tech looks like a very hefty and like so expensive matter. But if we see in the long run and the ROI is calculated, legal tech just brings down the actual cost which the law firms are putting to convert their clients into successful businesses. I would like now ask Pranjal to just move on the career paths which legal tech has actually opened upon.
Thank you, Ranjan. A very good evening to the panelists. So, the main topic of our today's session, of the second part of the session, career paths in legal tech, the non-traditional ways for the law students. We categorize career paths in 5 different categories. There might be others, but we majorly look at these categories. The first one being consultancy, the second one being legal tech operationalist, third one startups, fourth one vendor or being an agent of a legal tech startup, and the fifth one being legal departments or in-house counsels. So talking about the first category of career paths in legal tech, consultancy. Consultancy has been grown up as a majority of business in legal tech, since majority of law firms, MNCs or banking institution doesn't know how to use legal tech, or if they, or even if they know how to use legal tech, they don't know what to use and when to use. So consultancy as a legal tech career has been grown up since last 5-6 years. Going to the legal tech operationalist, law firms, MNCs, and banking institutions who are in regular in touch with legal tech appoints a person in their firm internally to get in touch the efficiency of the legal tech. See, legal tech can be used by everyone, but using it efficiently is a thing. So you can be a legal tech operationalist to look into the efficiency of the legal tech and suggesting the law firms or the institution you are working in on how to use it more efficiently. Going to the startups, I can give example of DreamLegal. Like we have started as a startup for legal tech. We are a legal tech marketplace for the products and the vendors. So with vendor, moving ahead, you can be a vendor or either vendor or agent. So if we talk about agents, you can become a reseller. You can get resellerships of some other products or some legal tech products to sell it in your country or to sell it in your particular region. Going to the legal departments, positions like chief innovation officer to manage the technology and the person using it has been grown up in these days. Ranjan, let's move to the next. Yeah. So what are the skills required to get a good career in legal tech? Uh, we can look at the slide as project management, team management, problem solving, analytical thinking, web and software development. But the thing is, these are just the generic skills which every management or which every employees need. But the thing is, we can deduce that study of law is not mandatory to get a career in legal tech, but law graduates definitely get an edge over others if they have knowledge of both law and tech. Moving ahead.
uh, as discussed by Pranjal, these were the career opportunities which are like very much being available in the legal tech startups or companies. Now, actually, if you see the another perspective, law firms are also in the requirement of the knowledge of legal tech, and that itself give rise to like many tons of opportunities in the legal departments. Let's say if I want to be in a law firm today, a law student would think that he would need the knowledge of law, but actually this has been changed by legal tech. Now, statistically speaking, there has been increase in the investment made upon legal tech project managers. Like, adoption of legal tech is itself a very complex process, and there has been rise in the legal tech project managers that help law firms to streamline all this process. Now, also there are data scientists, those are predicting the analysis and making the cases more predictive and more like tailored for the client. It is like the client would know beforehand that whether his case has the probability of getting the decision in his favor. That has been all possible because of legal tech. And with all this, legal tech opens various doors in the law firms also, with non-traditional roles which probably today in the law firms is not found. Now, if we talk about concludingly how legal tech is impacting, legal tech came upon industry like years back, but the digitization has not been that common in legal industry. But the COVID actually changed the perspective when lawyers were pushed to use video conferencings, and like judiciary, civil courts, and everything were on the like Google Meet and streamlined for streamlining and operating over computers and internet. That gave rise to legal tech, and that actually made the world to see what legal tech actually has in itself for the potential. Now, I actually also would like to answer the question which was touched, that whether legal tech is still a popular course or can be a popular course in like for the law students. For the India, I would like to say that it is like very much far from law students. I remember discussing I remember discussing legal tech with my professors and law students. It is like very much confused with tech law. Like legal tech hasn't been identified, but it is like misconfused with the tech that is around law. So that much far law students are still from legal tech. And I believe legal tech has potential to just change how legal services are being offered. The service of legal is like moving towards more productization, like not as a tailored service, but it is like more productized. People would be knowing that I would be getting this result from the particular legal service, and that is all possible just because of legal tech. So
Yeah, I would like to add up what Ranjan said about the awareness of legal tech in India and in other countries. It's a very popular stat that in UK 97% and in US 93% of lawyers and MNCs uses legal tech, but in India just 4% uses legal tech. So that's the difference and the gap we have to cover from India's side. And if we talk about other countries, I have seen like many colleges providing MSc courses in legal tech. Like University of Law in UK also provides a course in legal tech. So that's the thing we need to cover up in favor of India.
Mm-hmm. Yeah, this is a great presentation, Pranjal and Ranjan. Thank you so much. And just, I think, 9 minutes or so, you guys painted a very sort of, you walked us through all like the global trends. And I think like personally, like, I can resonate with your excitement for legal tech because it is a growing industry. And I think for me, like the most powerful thing that I think like legal tech or legal design is like unlocking for people right now, not just the value in contracts, but the ability for lawyers to really take control of their careers. I think it's opened up so many interesting avenues. I think you guys, as entrepreneurs, Tessa, I think Gunjan, they're all like very, very good examples of what, non-traditional, legal careers look like. You could be a product manager, you could be a CEO, you could be a CIO, Chief Innovation Officer. And I think personally, for me, all of that is very, very, very exciting. I want to bring back the discussion to a little bit more about just the value of legal design and legal tech. And we have a lot of students here, so I'll bring it in the context of the students. Tessa, I want to go to you next and just ask you, you've done several courses on legal design. And we were earlier speaking about how like legal design and legal tech should be made part of law school curriculum. I'd be very curious to hear a bit about your experiences teaching these subjects and any sort of like advice or insights you'd like to share with the students we have here today.
Yeah, it would be a pleasure to share some tips and advice as to how, as a law student, you can start this journey in legal design. So I think first we need to know, who is this for? Who is legal design for? I think it's for the law student who maybe like me back in the days, who was feeling maybe that the traditional way of working in law is not just, making you so excited and happy. I mean, at least for me, it was like, oh my God, I wish I could use my creativity. I wish we could use more technology, because I think also legal design and legal tech goes so well together. And I felt this creativity. I felt this spark of wanting to innovate, but I just didn't know how. So at the time I had to research and investigate, and eventually legal design became a thing as a word. And that is great because it gives us a name to kind of say what we do. So I think this is great for the kind of law student who has some creativity, who wants to innovate, who wants to be at the forefront of doing things differently, trying new things, being curious, being open, willing to experiment, willing to try, willing to fail as well. And so if this is you, I think there are a couple of things you can do. First, there's lots of resources that you can read online. If you just Google legal design, you will find so much on LinkedIn. For example, you will find a book from Margaret Hagan, lawbydesign.co. We're working on the book too, the Legal Creatives book, so it's hopefully going to come out next year. But I think reading is the first good step. Then you have to practice. So this is why at Legal Creatives, we offer very practical courses, very hands-on, for you to be able to actually, get to do something with the theory, get to produce a new contract, get to think about innovative projects, whether it could include technology, like no-code platforms and so on. So the courses we provide at Legal Creatives are a great way for you, even if we have more professional. We did have students, and we're always happy to have students and to help them start on this journey. Now, in the universities, there are also courses. I curated and delivered, I believe, what is probably the first course ever in the law faculty just focused on creativity, because this is how I got to discover legal design, through creativity, which is a structured problem-solving methodology, and that is what all legal design is about. And so these opportunities, for you, if you are really motivated and determined to show the research, and I'm happy to help you with that, and to go to your faculty, and I'm not sure if there are yet legal design courses in the faculty in India. But even if they are, we need more. So you can go and say, look at all the research, this empirical research now, this qualitative research. So there's lots of readings you can do, and just go to the faculty and say, why don't we give it a try? Why don't we do like a webinar like this, like you're doing? It's so great. And I'm so grateful to be here as well. A mini course, like a mini workshop. And eventually maybe you can have this part of the curriculum. Hackathons are a great also option. We have done one recently in the metaverse, and that was great because we were able to use the technology and the metaverse and have lawyers and law students from all around the world tuning in. So you could do hackathons, you could do legal design sprints, you could do workshops, webinars. There's just so much to do. We're just at the beginning. But my recommendation would be to take action. Either you can start reading, educating yourself, practicing, and just spreading the news. I think it's very important to show that this is not just a fancy thing. This is a very useful methodology for lawyers. And this is going to be the future. We are seeing that in the industry today, when we think about terms of use, for example, and online websites, nobody reads the terms of use, or at least if people read, they have a hard time to understand. this, now we're moving into the Web3 with the metaverse. Are we going to keep those long privacy policies that nobody reads and have people click, I accept? I mean, the metaverse the Web3 is so interactive and visual. Can we be more creative? Can we find a better way to communicate on this legal information that is more in sync with what customers expect, and that is also leveraging the existing technology? Yesterday, I was giving a plain language workshop, and I was just recapping the history of how, we have so much more tools than we used to have. Before, we just had pen and paper, right? And now, then eventually we got the typewriter, the dictaphone, the computer software like Word and so many more. Now we have Canva. How about we start leveraging those new technologies and tools to practice in a way that is more modern, that is more in sync with what clients expect? And so, I hope this is useful. I don't know if I answered the question well, but yeah, read, practice, and spread the news.
Yeah.
And connect with me if you would like to continue the conversation. I'm always happy to, very accessible. So yeah, thank you for the opportunity to share.
Of course, and you answered that very well, Tessa. I just want to, as a sort of a closing question, I would like to ask all three of you, actually, when we talk about tech adoption and keeping up with the times and getting updated in the context of lawyers, how good do lawyers need to be with technology? Is this something that you just need basic technical skills, and is this something you can learn? Or as a law student, should you be worrying about learning coding, or should you not worry about those sorts of things? And is this an accessible field, I guess, for someone that does not have any sort of technical background?
Well, answering Aishwarya ma'am, I believe for lawyers, the knowledge of technology or basic coding is not required. To me, I believe that technology is not the problem, but lawyers are still unaware of the right fit of the technology, where it can be implemented to make services or their operation simple. So instead of imbibing the knowledge of softwares or codings and all, if they're more streamlined with the use case that what that legal tech is offering, the knowledge of that and some awareness around that area, it is more required and will help legal tech with easier and more accessible adoption. That's what I believe.
Yeah, absolutely. And Tessa, what's your perspective on just how good lawyers need to be with tech?
Well, thank you for the opportunity to clarify this really important question, because I think there's a big myth that you can do legal design if you don't know how to do the design. And there's another myth that you can do legal tech if you don't know how to do the tech. In fact, this is a big myth in the sense that to do legal design, what you need to learn is the way of thinking like a designer. A designer is always thinking about the user. Who is my user? What are some of the difficulties that my user has, for example, in reading the document, understanding the information, just working with me as a legal professional? Can I make the customer experience better? Of course, there's always room to improve. And I know that lawyers are very, very proud of the way they interact and care for the customers, but I think the methodology helps us in a more structured way collect the feedback in a systematic manner, and that feedback is so important to see what are the rooms for improvement. And sometimes we realize they can be small tweaks, and sometimes you may realize you need to make big changes, and that's okay, because in this world where there's so much competition, we need to always be attentive to what the customer needs and wants. So the legal design methodology helps you think about, how you can improve the surveys. And then the way you can improve can include visual, and then you can work with designer to help you with that. Or if you want, you can learn how to design yourself. I know many lawyers who got passionate about design and started to learn how to do the design. We do teach a little bit that, but we more advocate for the collaboration with professional designers because they are great professionals that can help you, that have lots of experience. And if you were to start learning design today, well, there's people who have done that for 5, 10, 15, 30 years, and they have a lot more knowledge than if we start today, right? It just makes sense. So collaborate with designers if you need to do the visuals, collaborate with technologies if you need to have no-code solutions or more technological solutions. But I think the legal design is just the thinking process and the methodology. And then it's about collaboration and interdisciplinary work. So depending on what you want to do with the insights you collect, then you can decide, depending on the budget you have, also how you want to position yourself in this industry. Do you want to be like a super tech law firm, or do you rather have a different approach? So the legal design methodology is helping you think through those questions and decide for yourself what is the best approach. So you can niche yourself. You can develop some differentials and be different, because in today's world, again, with the competition, you want to stand out. You don't want to be just a regular law firm, because then you're just a commodity and clients can go to another law firm. So you want to, try to find ways to stand out. You want to try to find ways to be different. And you want to try to find ways to really be aligned with your purpose and your mission and your values and the way you want to deliver the service. And this methodology helps you think about that. So you can get started without design knowledge, without tech knowledge, and just start thinking about those problems. And then eventually getting creative to find solutions that will be aligned with what you want to achieve in your career as a legal professional.
Yeah. Wow, it's a very good way of putting it. And I think just throughout this webinar, we've had themes where, like, we've talked about, start thinking, get creative, be empathetic, think about, building relationships between stakeholders, think about transparency and communication, and just innovate. So I'm very grateful to, Tessa, DreamLegal, Gunjan, and Dr. Bangali for joining us today and being part of this conversation. And this has been such a pleasure for me. It is now 6:30 a.m. here in Berkeley, but I feel so energized after this conversation. So thank you so much for taking the time to join, and thank you so much to all our wonderful audience for tuning in. Check out DreamLegal. They're doing really great work. They're very innovative. I personally really appreciate everything that they're doing. So go to their website, check them out. Check out Legal Design Arc, which Gunjan is working on. She's a really talented legal designer. Check out Tessa's work. She is great with legal design. She has a lot of useful courses and insights. So definitely check that out. Check out MyLawman. They're doing very, very important, innovative work in making legal education much more accessible. And check out SpeedLegal. We're also doing innovative legal work where we're trying to make legal documents and contracts accessible for everyone, especially for lawmen, laymen, the opposite of lawmen, laymen, so that everyone can understand contracts in simple, plain language. And we do have speaking of career opportunities, SpeedLegal is always looking for talented, motivated interns to join our team and help us innovate. So definitely check us out. We'd love to hear from you. And thanks to the speakers and all the audience once again. It's been wonderful.
Thank you so much. It was lovely speaking with you.
Thank you so much for having me. It was a pleasure to share.
Of course. And with this, we'll close the webinar for now, and I look forward to keeping the conversation going on LinkedIn and many other venues where we'll all stay connected. Thank you, everyone.
Thank you.